Hello and welcome, future CAs. I know the Indian Contract Act of 1872 can seem like a mountain to climb, but honestly, it all boils down to a few key rules. So in this explainer, we're going to build a legally valid contract from the ground up, giving you the solid framework you absolutely need to ace this part of your exam.
So let's kick things off with a super common scenario. You and a friend make a deal for their old phone. You agree on a price, you shake hands. It's a done deal, right? Well, hang on. In the eyes of the law, it's not quite that simple. So what's the real difference between a casual promise and a contract that a court will actually enforce? That's exactly what we're going to figure out today.
All right, here's our game plan. We'll start with the master rule from Section 10. Then we'll dive into the 4 essential pillars of a valid contract: who can actually make one, what free consent really means, why the purpose has to be legal, and finally, we'll look at some agreements that are just doomed from the start. Okay, so this right here, Section 10, this is the big one. It's the gatekeeper. Think of it like a bouncer at a club. It says that for any old agreement to get in and become a real, legally binding contract, it has to meet certain conditions. These are the absolute non-negotiables.
First things first. Not just anyone can walk up and create a legally binding contract. The very first question the law asks is, are the people involved actually allowed or competent to make this kind of promise? This brings us straight to our first pillar, the capacity to contract.
And Section 11 lays it out for us, plain and simple. It's basically a 3-point check. Number 1, you have to be at least 18 years old. Number 2, you have to be of sound mind, which means you actually understand what you're agreeing to. And number 3, you can't be disqualified by some other law. Pretty straightforward, right? Now, this is a huge one for your exams, so listen up. An agreement with a minor isn't just invalid. It's what we call void ab initio. You have to remember that phrase. It means the contract is treated like it never, ever existed. It's dead on arrival. This gives minors a really powerful legal shield. And if you need a perfect example, look no further than the landmark case of Mohori Bibi versus Tharmo Das Gose. Long story short, a minor got a loan, and the court's decision was crystal clear. The agreement was totally void. The lender couldn't get their money back because you simply can't form a valid contract with a minor. This case is the bedrock of that rule. Okay, so we've got the right people at the table. We're good to go, right? Not so fast. The next step is making sure the agreement itself is genuine. This is our second pillar, making sure that the yes from both sides was truly free. It had to be given willingly, without any funny business like pressure or lies. You know, the law has a fancy Latin term for this, which you'll definitely want to remember: consensus ad idem. It just means a meeting of the minds. It's not enough for both people to say yes. They have to be agreeing to the exact same thing in the exact same way. If you think you're selling me your 2020 model car, but I think I'm buying your 2022 model, we don't have consensus. So what can mess up this free consent? Well, the law is very specific. It lists 5 things that can poison the well. Think of these as the 5 contract killers: coercion, undue influence, fraud, misrepresentation, and mistake. If any of these are the reason you said yes, the contract could be in big trouble. Spotting the difference between these two is a classic exam question. Coercion is the sledgehammer approach. It's physical force or threats. It's the gun to the head scenario. Undue influence, on the other hand, is way more subtle. It's about someone using their position of power or trust over you, like a doctor over a patient, to unfairly pressure you. One is about brute force, the other is about abusing a relationship. Here's another critical comparison. The bottom line here is all about one thing: intent. Fraud is when you tell a lie on purpose to trick someone. You know what you're saying is false, but misrepresentation is an honest mistake. You say something that's false, but you genuinely believe it's true. The difference is huge, especially because you can sue for damages in cases of fraud, but not for innocent misrepresentation. All right, moving on. Even if you have the right people and a real yes from both sides, the whole deal can still fall apart if what you're agreeing to is, well, illegal. This brings us to our 3rd and 4th pillars, which are all about making sure the contract has a lawful purpose. Section 23 basically gives us a clear checklist of what's off limits. An agreement is unlawful if it's forbidden by a specific law, if it's designed to defraud someone, if it would hurt a person or their property, or if a court just thinks it's flat out immoral or against public policy. Now, that term public policy might sound a bit vague, but it covers things that are bad for society as a whole. So think about it. An agreement to trade with an enemy during a war? No. A deal to pay someone to keep quiet about a crime? Absolutely not. Paying a bribe to get a government job? No way. These are all void because they undermine the public good.
And for our last hurdle, there are some types of agreements that are just doomed from the very start. It's not that their purpose is necessarily evil or illegal, but the law has just put up a big void stamp on them. No questions asked. They're unenforceable by their very nature. If you look at this list, you can really see what the law values. Agreements that stop someone from marrying or from working in a legal profession are void because the law protects personal freedom. An agreement that's so vague no one can figure out what it means? Void, obviously. And wagering agreements, which are basically bets, are void because courts don't want to get involved in collecting gambling debts. So let's pull it all together. This is your 4-pillar checklist for every single agreement you analyze. 1. Do the parties have the capacity? 2. Was there free consent? 3. Is the object lawful? And 4. Is it a type of agreement the law hasn't already declared void? You need a solid yes for all 4. If even one of these pillars is shaky, the whole contract can come crashing down. So here's a challenge for you. The next time you click I agree on a new app or sign a service agreement, just pause for a second. Try to spot these 4 pillars. Applying this framework to the real world is the absolute best way to make it stick. Nail this 4-part test, and you're building the foundation you need to master the Indian Contract Act. Good luck with your study.